Ladies and gentlemen, good afternoon. I am George M. Chalos. And if you believe this, you will also believe that the next time your ship undergoes an extended MARPOL inspection by the U.S. Coast Guard, they love you, they will cooperate with you, and give you a medal. George has what lawyers call a scheduling conflict, and he's unable to attend. So we scrambled around in our firm to find another George, and we only found me. I am George Gaitas. I'm a partner in the firm's Houston office. I lack George's youthful exuberance, but what I lack in that department I can make up with raw cynicism, which one needs to have in talking about magic pipes. Because in the last 10 years, this plague continues unabated, and nobody seems to be able to do something about it. Now, I presume most of you know what we mean when we talk about magic pipes, but very generally, what we mean is the unlawful bypassing of the vessel's oily waste management system in violation of MARPOL 7378 Annex 1. Various devices are used for this purpose, and they go by the generic name magic pipe. They range from the very sophisticated to the very crude and primitive ones. Now, here's one of those very crude and primitive ones. It consists of a hose with two flanges. Here's another one. Now, the idea on this thing is to connect one end at the source of the oily waste and the other end on overboard discharge with the aid of some kind of a pump, like a sludge pump. You pump, and instead of sending the oily waste through the ship's oily water separator or incinerator, you send it overboard. Now, why is the United States so special about this? Well, the reason the United States is so special about this is because they have very stiff penalties for ships they catch engaging in this practice, and they pay very high rewards to the snitches, and the snitches are known in the industry as whistleblowers. Now, let's look at the legal framework of this. MARPOL is an international convention that does not contain its own built-in enforcement provisions. So each state that has MARPOL jurisdiction must do its own. Now, there are two jurisdictions that are involved in MARPOL enforcement. One is the flag jurisdiction, flag state, and the other is the port state control jurisdiction. The United States has grafted onto MARPOL its own enforcement provisions under a piece of legislation that is called the Act to Prevent Pollution from Ships. And as you know, MARPOL requires the keeping of a document which is called an oil record book, and the oil record book is where you record overboard discharges of oily waste. Now, some states enforce MARPOL with administrative regulations. In the United States, the regulations include provisions of APS, the Act to Prevent Pollution from Ships. They include criminal sanctions. There is a section of 33 U.S. Code 1908A, which says that if you engage in prohibited activity, you're guilty of a Class D felony. A Class D felony is the lowest felony there is. What you get for it is 5 to 10 If you're a corporation, you pay a fine of $500,000 maximum per count. And this is not all. Now, some years ago, some smart lawyers in 2008 figured that since MARPOL prohibited events take place in the oceans, this is why MARPOL exists, they could not be prosecuted with criminal statutes in the United States because the United States does not have jurisdiction over the oceans. They ran that argument in the U.S. District Court for the Eastern District of Texas. They were defending a chief engineer, and they won. Unfortunately, the matter was appealed to the Fifth Circuit, and it ruled that the substantive violation in the United States is not dumping of oily waste overboard in the ocean. It is keeping an oil record book that contains false entries while you're in the United States. So basically, APS is about records keeping, and that's the substantive offense. The government, in instituting APS prosecutions, uses two other statutes who are very, very similar, and they accumulate the charges. On top of the APS violation, they'll charge you with the violations of the False Statements Act, 18 U.S.C. 1001, and with violations of the Obstruction of Justice Act, 18 U.S.C. 1505. The False Statements Act is whoever shows a falsified document to the government investigating the matter is guilty of a Class D felony. That's another 5 years. And obstruction of justice, if you have your superintendent engineer who tries visiting, by the way, to counsel and help, and he tells the chief, don't say this, don't say that, there's another count of obstruction of justice. So you're looking for violation of 3 charges for one offense of $1.5 million. What's the latest in prosecutions? The prosecutions for APS violations that we are seeing continue aggressively and unabated. The Department of Justice has a special group of people within that do this kind of work. They are called the Environmental Crimes Division. They are extremely zealous about their work. They carry it on like they're missionaries, and you would say that they are a species of modern-day crusaders. Now, the target of the prosecutions that we're having these days is not anymore the old substandard ships that they were saying they were trying to eliminate. The target we have these days is largely young, state-of-the-art, well-managed, well-organized, with good quality and safety departments, with good training programs, strict procedures for pollution prevention, etc. None of this is going to help you if you're caught in this web. Why? Because whistleblowing has become a profitable racket, and it is a setup for a shakedown. And guess what? The government is aligned with the whistleblowers. The whistleblowers set you up. They make the magic pipes. They connect them. They use them. They turn you into government. They admit that they did it, but they blame the ship. And they say it's the chief engineer who told me to do it. And I did it because otherwise I was afraid I was going to lose my job. Your company gets blamed for it. Your ship gets stuck in negotiations over her release because she's detained. You put up an enormous amount of money as security, and eventually you're forced down to bargain and take a fall, even though it's not your fault. Whistleblowers are given an incentive by the reward system because, I forgot to mention, they're not entitled, in the judge's discretion, they may be awarded up to 50% of what fine the government assesses. So in the case we mentioned before, if the fine is $1,500,000 for a single violation, you do the arithmetic. They get half of that. So what can you do about it? Is it the fault of the ship? Taking it from an archetypal cynic, my hero, Διογέννης, τα βαπόρια δεν φταίνουν ποτέ, τα γραφεία φταίνε. Ships are never at fault. It's the officers that are at fault. Suppose your ship sails in Houston or New Orleans tomorrow, and some oiler slips a note to the port state control guy who comes on board, the Coast Guard man, that says, sir, they're doing all kinds of terrible things on board the ship. He investigates, and then the complainant comes up with a rubber hose and a couple of flanges at its end. And you have this kind of situation in which you have to explain what in God's name this is. What are you going to do about it? You're in the office in Greece. Have you trained this guy how to respond? I'm telling you, it is, by the time it reaches this state, it's too late. It's very difficult. So, you have to be prepared, and you have to be prepared ahead of time. The waste oil management system on any given ship is not a very complex thing. It's a very simple, closed system. So do a prevention program. Regularly check it for tampering. I cannot tell you how many times we've come across these systems in which somebody has installed a tap, a permanent tap, for connecting their hose. Check for signs of trouble around flanges that can be taken apart. Is there abnormal wear of the bolts or the paint? Something's gone on. Check for oil spills. Whistleblower-proof things. Very simple. Where you have trouble spots, use seals. Have a little hole drilled into the flange, put a wire and a lead seal. Control them. There are a number of products in the market for this business. Accountability. Those whom you assign to do the jobs, to operate the system, you have to monitor them on board. Practice zero tolerance. Don't just write about it. You catch somebody that you even suspect doing monkey business, fire him. Make it known throughout your company. Maintain permanent records, not bits of paper. You should have a sounding book for sounding the tanks that contain waste oil products, sludge, oily bilge. Not little pieces of papers. When the Coast Guard calls for these things, you have them, you show them to them. Show them that what goes in the oil record book is what goes in these records. You should have a log that shows when your oily water separator has worked, that should be duplicated in the oil record book. Same thing with your incinerator. Closely control abused supplies. There is no reason that everyone should have access to flexible hoses and flanges, prime material for making these things. Keep them under lock and key. The office should regularly review the oil record book. They should get copies. They get copies of so many things every day. That's one more set of papers. And see, does it make any sense to you? Very often when the Coast Guard comes to inspect, they find out that the oil record book is written in a way that is nonsensical. Log the inspections. Have surprise inspections, maybe headed by the master. Search areas where they could be concealing equipment like this. Spare compartments and rooms in the engine room. Lockers are favorite places for hiding magic pipe hoses. Then there is something that you can do from the office. When the Coast Guard comes on board to investigate, they routinely ask, who is the operator of the ship? And people very eagerly say, give the name of the management company. Oops. Operator in APS has a very, very special meaning. Be aware of it. It is the guy who, other than the owner, who is responsible for the operation, manning, victualling, and supplying of the vessel. If you tell them that you're the operator, they'll write you up. And the next thing you know is they want to bag your entire fleet. That's why they ask. So if you manage 10 ships, they will all go in the compliance program. So rethink this thing as to who is the operator and rethink what you tell folks who you are. I think it's a bad thing to describe the manager as the operator because he's not. Avoid the manager's names on stationery and paper supplies because that's a telltale sign as to who is the operator. Make it clear to masters and agents that the managing company is not the operator. Use the magic word as agents only in describing yourself and in your correspondence. What you say to the Coast Guard matters very much. You are what you say you are. Remember what the big fish told the small fish. Keep your mouth shut and you won't get caught. Thank you.